channels RR Corporates and RR Legal Talks. Now we are discussing a very important topic, that is shareholders versus directors under Companies Act 2013. So we are going to discuss in view of their roles and duties, rights and legal provisions. So who really runs the company, shareholders or directors? In this detailed session, we decode the legal definitions, roles, rights and responsibilities of shareholders and directors under Companies Act 2013. Learn their difference, appointment, powers and liabilities. This video is perfect for CS, CMA students, aspirants and corporate professionals. Welcome to this detailed discussion on the differences between shareholders and directors under the Companies Act 2013. So in this video, we will explain who is a shareholder, who is a director, and legal definitions, appointment and the eligibility, key differences between shareholder and directors. So who is a shareholder? We'll see the definition section 2, subsection 55 of Companies Act 2013. A member or shareholder refers to the subscriber to the memorandum of association who shall be deemed to have agreed to become a member of the company and on its registration shall be entered as a member in its register of members. So subscriber to the memorandum of association. So at the time of incorporating a company, so the subscriber to the memorandum of company who shall be deemed to have agreed to become a member of the company and on its registration of the company shall be entered as a member in its register of members. He will be entered as a register of member. Types of shareholders. Subscriber to the memorandum of association, we just discussed at the time of incorporation, and then later purchase of shares. So purchasers of the shares during the further issue of share capital. Then transferee or allottees through sale or through gift or through inheritance. So first time subscriber to the memorandum of association at the time of incorporation of the company, they will become the shareholders. Then purchasers of the shares during the further issue of capital, they will become the shareholders. Whether with the transferees or allottees, whether through sale, gift or inheritance, they will become the shareholders of the company. Then here are the key points. A shareholder can be an individual, shareholder can be an entity, shareholders are the owners of the company. Their rights including voting rights, dividend rights and receipt of financial statements. Shareholders exercise their power through general meetings, AGM or EGM. Shareholders do not manage day-to-day affairs of the company. Then what are the rights of the shareholders under Companies Act 2013? Section 47, right to vote, right to receive dividend if declared. Section 94, right to inspect statutory registers. Section 241, right to apply for operation mismanagement. These are all the rights of the shareholders under Companies Act 2013. Who is a director? So legal definition as per section 2, subsection 34 of the Companies Act 2013. A director means a director appointed by the board of company. Eligibility, only natural persons can be appointed as directors. Minimum age 18 years. Must have a DIN number, director identification number, as per section 153 of Companies Act 2013. DIN means director identification number. Now it is a mandatory. Before appointing a director, it is a mandatory. Or at the time of incorporation, yes, we will get the DINs also. Appointment. Directors are appointed by shareholders at general meetings. Board will appoint additional directors. Then they will be regularized in the general members meeting. Board, in case of casual vacancy, or additional directors will be appointed by the board and appointed by as per the articles of association. Types of directors will be knowing. No, we'll talking about executive director, non-executive director, independent director under section 149, nominee director under section 149, additional director under section, nominee director under section 161, additional director under 161, alternate director under 161, women director. The women director is mandatory for only certain companies. So these are all types of directors. Section 166, duties of directors. So director shall act in a good faith, exercise duties with due care and diligence, avoid conflict of interest, not assign their office. They cannot transfer, director's office cannot be transferred. These are all the duties of the directors under Section 166 of Companies Act 2013. Then we see the liabilities of the directors. Directors can be held personally liable for breach of fiduciary duty, fraud, Section 447, non-compliance under various sections. These are the liabilities to the directors. Now, overall, we will see the differences between shareholder and the director. We see the roles. Shareholders are the owners of the company. Director, managers of the company. Shareholders are the owners of the company. Directors are managers of the company. Definition: if you see shareholder, member under Section 2, subsection 55, whereas director under Section 2, subsection 34 of Companies Act 2013. Appointment. So shareholder, how shareholders will come into the company, subscribing or acquiring shares. Whereas the directors appointed by the shareholders or board. Any casual vacancy or additional director appointment by board. Generally, they are appointed by shareholders. Eligibility. Shareholders, no individual or legal entity can be a shareholder. Directors, only natural persons. Only natural persons are the directors. And if you see the primary function, shareholders invest capital. Shareholders vote on key decisions. Directors, strategic operational management. Their duty is one primary duty, strategic operational management. Come to the liabilities. Shareholders are liable limited to unpaid share capital. Whereas directors, personal liability for misconduct. They are personally liable if there is any misconduct. Decision making. Shareholders voting on major matters. Whereas directors, day-to-day decisions and board resolutions. This is the difference between the decision making, shareholders and directors. And minimum requirement, if you see shareholders, 1% company, one shareholder, private company, 2 shareholder, public company, 7 shareholders. Minimum requirement, 1% company, 1 shareholder, private company, 2 shareholder, public company, 7 shareholders. Minimum requirement of directors, 1% company, 1 director, private company, 2 directors, public company, 3 directors. Public company, 3 directors, private company, 2 directors. What about the remuneration? Shareholders, they are entitled to dividend if declared. Whereas directors, paid sitting fees, salary, commission. What about transfers? What about renewal? Shares transferable as per AOA. So shareholders, they can sell the shares, buy the shares. And directors can be removed by shareholders under Section 169 of Companies Act 2013. Director can be removed by shareholders under Section 169. Shareholders are owners of the company, directors run the company. Shareholders own the company, directors run the company. Shareholders have indirect control, directors have direct control. Shareholders have indirect control, directors have direct control. Shareholders can appoint or remove directors. Shareholders can appoint or remove directors. That is the power of the shareholders. Directors act in a fiduciary capacity, their duty. Removal of the director, if you talk about Section 169, Section 169 Companies Act 2013 talks about the removal of the director. Shareholders can remove a director by passing an ordinary resolution in its general meeting. Director must be given an opportunity of being heard. There are exceptions not applicable to directors appointed by tribunal or under proportional representation. So the exception to Section 169. So not applicable to directors appointed by tribunal or under proportional representation. Now we discuss transfer of shares. Shareholders free to transfer shares subject to represent restrictions. Under AOA, Section 56 talks about, see, suppose transfers, free transfers subject to restrictions under AOA and Section 56. Directors not transferable, only remove or resign or retire. That's all. Role in corporate governance. So, whose role? To what extent? Shareholders ensures accountability by approving financials, appointing auditors, voting on major matters. Whereas directors ensures management by conducting board meeting, Section 173, ensuring legal compliance, signing financials, Section 134. Then the conclusion is shareholders are the foundation of the ownership. Directors form the backbone of the management. Both roles are distinct and necessary for balance. Understanding the difference is essential for legal compliance, investor rights, and good governance. Are you a shareholder or planning to become a director? This video breaks down your duties and rights as per the Companies Act 2013. So please do subscribe for our two channels, RR Corporates, another channel, RR Legal Talks. Hit the bell icon so that you will not miss any of the latest update on corporate laws, NCLT matters, and public issues. Thank you.